Welcome to the Probate Nation. My name is Richard Ruddy. Estate planning often involves consulting with an attorney to discuss your goals and objectives, and typically that consultation seeks to gather information through an estate planning workbook that you're asked to complete. A prior show in this series on will-based planning examined the personal information needed about you, your family, beneficiaries, and advisors. We refer to these people as the who in an estate plan. Our show tonight and next week focuses on the what in an estate plan. This is an inventory of the assets you have. The goals of these two shows are to educate you as to the importance of this important information, provide tips to consider in handling each asset, and identify quick fix pitfalls to avoid. We are pleased to have with us tonight two Northern Virginia estate planning attorneys. They will lead us through a typical estate planning workbook that gathers asset information. So let me introduce our guest. Our first guest is John Morgan, who's a shareholder with the law firm of Rees Broome in Tysons Corner, Virginia. His practice focuses on estate planning, estate administration in Virginia, Maryland, the District of Columbia, and West Virginia. He is a graduate of the College of William & Mary and the Catholic University of America, Columbus School of Law. He has an LLM in taxation with distinction from Georgetown University. Plus, he is a certified public accountant and a certified financial planner. Also with us today is Alexis Abraham. Alexis is an associate with Bromley Law in Fairfax, Virginia. Her practice focus is estate planning and administration, guardianship and conservatorship proceedings, and estate litigation. Alexis also frequently serves as a fiduciary for trust and estate. She is a graduate of Virginia Commonwealth University and George Mason University School of Law. Please welcome attorneys John Morgan and Alexis Abraham. Welcome to both of you folks. Thank you so much for coming on the show. I'm going to jump right into it, John, because we have a lot to cover over two shows. So tonight, John, what information, let's talk about real property, which is often probably one of the single biggest assets in many estates. What information is typically needed about real property?
Well, to start, we're looking for the type of property it is, whether that's a single-family home, a townhome, a condominium, co-op. Different rules apply to transfers with respect to different property. We'll also want to know the jurisdiction in which the property is located. If we can't do a deed, maybe we can associate with an attorney licensed in that jurisdiction who can. We want to know who the owner is, as well as the fair market value of the property, and if there is a mortgage on the property, what the balance is of the mortgage.
So why is the type of property important as far as, because I know there's different types of property that we face in estate planning.
Sometimes a single family home is not going to be subject to the same restrictions on transfer that condominiums or sometimes co-ops are, where there are maybe the association needs to sign off on the deed. If that is the case, we want to be aware of that from the beginning.
And tell me, why is the state where the property is located important?
Among other things, we want to know if there's an opportunity to avoid not only probate in the jurisdiction in which the person lives, but potentially ancillary probate in another jurisdiction. That is not a process that is normally desired by our clients.
Alexis, let me turn to you as we continue this discussion. Why is the legal owner of the property important to know?
The way the property is titled determines who inherits it and whether it passes through probate. And in certain cases, ownership may need to be adjusted to better accomplish a client's estate planning goals.
Okay. Now, tell me a little bit, why is it important to know, John mentioned about mortgage, why is it important to know if the property has a mortgage on it?
A mortgage can affect whether the property needs to be sold, refinanced, or potentially paid off from estate assets. And the loan documents and the lender requirements matter here.
So if you have a mortgage, does the estate have an obligation to pay off the mortgage when somebody dies?
Not automatically. So in Virginia, general language in a will to pay off the debts and obligations of the decedent is not enough. Mortgages typically convey with the property. So an estate plan needs to be very specific if it is your intention to have the mortgage paid off from estate assets.
Now, when you say to be very specific, you're saying that in the will, they need to very carefully indicate that we want the mortgage on this property paid off. Is that
Correct.
what I want to make sure I understood that. Now, is there a probate tax, at least as far as Virginia is concerned, is there a probate tax on real property?
If the property passes through probate, then yes, it is subject to a probate tax.
Okay, so that means if it doesn't have a beneficiary designation or it's not held jointly, it goes through probate, we got to pay a probate tax.
That's correct.
Now, for every $1 million of value, as I recall correctly, that's about $1,000 in probate tax?
That is correct.
Yeah, so that's something for people to keep in mind. John, let me turn to you. If Virginia and some other states, but not all, have approved the use of a special type of deed called transfer on death, or TOD. Can you explain how that works?
A transfer on death deed is the type of deed that can be recorded in the local land records that basically says the owner stays the owner until death, but then upon the owner's death, the property goes to another person. It's typically a revocable transfer on death deed, so the owner can change the beneficiary at any point in time.
Okay. Now, are there any problems to keep in mind with the use of a transfer on death deed?
Potentially, yes. It could conflict with the other terms of a person's estate planning documents. It may not adequately cover contingencies in terms of the beneficiaries who may or may not survive. And it's also critically important to look at any insurance policies on the property to see whether they are also cover the new transfer on death owner, because they very likely will not.
Yeah, we had been discussing that very issue in another case that came up where the house burnt down and the transfer on death deed passed, and the insurance company would not pay for the insurance on that particular property. So that was very, very discouraging. Well, let's turn to a different topic, which is the next thing that we see is we have the house, but inside the house we have all kind of furniture and personal effects, Alexis. What types of assets are we focusing on here?
Here we're talking about our everyday personal items, the things we can see, touch, and hold, such as our furniture, our clothes, jewelry, tools, family photographs, and our other personal belongings.
And do these assets typically have like a formal ownership title, or much value for that matter?
Usually no. So most personal effects don't have a formal title. And very often they don't have much financial value beyond sentimental. So here when I'm talking with the client, I certainly want them to let me know if we are a collector of things that are going to be more valuable, like jewelry, painting, art, things like that.
So, and then of course, why is this information important though, to understand about all these different things sitting around the house?
Yeah, so these items can still be really important to families, especially when we're talking about heirlooms, jewelries, family photos, things a client might want to specify where they go.
Okay, I agree with that. Now, John, I'm going to come back to you. Is this the type of property, this furniture and personal effects, is this typically given away with language in the will?
More often than that, I would have catch-all language in a will that says I give my tangible personal property to this beneficiary. But if there is some specific bequest with an article of stuff, tangible personal property, I would normally recommend that be done with a separate memorandum that gets attached to the will that can be changed over time without the need to change the will itself.
Now we refer to that as a personal property memorandum. Is that what we're talking about?
That is what I'm referring to, yes.
Yeah, so that tool is really so helpful because, as you said, you don't have to come back and see the lawyer. And of course, you can change your mind over time and just go ahead and scratch that out and do something differently. But yes, I think that's a really, really great tool, and it's very much preferred. I know an early will that I did back maybe many years ago, I don't want to say how long ago, there was about 10 pages that all gave away everything in the house by way of personal property. And then, of course, every time they wanted to change that, they had to come back to amend their will. So that's a good thing, to use the personal property memorandum. Alexa, I'm going to come back to you now as we change our topic now, automobiles, boats, and RVs. What information is typically needed about these types of assets?
Sure, so we want to collect a description of the asset. We want to know how it's titled, We want to have an idea of an approximate value and whether there are any outstanding loans or liens against it.
Okay. And do these assets typically have a formal legal ownership title issued by a state?
Yes. So here in Virginia, cars and RVs are typically titled through the DMV, and boats are generally titled or registered through the Department of Wildlife Resources.
So, and again, sometimes if these particular assets are subject to a mortgage, is that important to know? Or a lien of some kind, maybe a car loan or something like that?
Yeah, we definitely want to know if there's a lien, because a lien can prevent the asset from being transferred until that loan is addressed. As the lien holder typically will hold the title still to the property, not the owner, until the lien's paid off.
So tell me a little bit about how cars and boats are, how are these typically titled? Because we're going to have to title them with these agencies.
Most often we see they're titled just in one person's name. However, they can be jointly titled, and in certain instances they can have beneficiary designations as well.
Yeah, I think it's important to mention that, at least in Virginia, the beneficiary designation for a car has to be a person. It can't be your revocable trust. Well, John, why is the value of these assets in cars, RVs, and boats, why is that important to know?
It's important to know the value of these types of assets because they go through probate oftentimes when other assets like financial accounts with beneficiary designations do not. We want to know whether these automobiles and similar assets might push an estate over the threshold so there's a full-blown probate rather than that small estate administration.
Okay. Now, in your experience, how do most attorneys recommend that these assets be handled in a will project?
At least for this attorney, if there's a married couple, unless there's a really specific reason that a married couple does not want to own a vehicle jointly, I do recommend that that is how it's handled. I agree with Alexis's experience that I very often see a vehicle titled in just one spouse's name. And that's often inadvertent or because one spouse happened to go to the DMV and register it or went to purchase the car.
Right.
But that is what I prefer to do, at least for a married couple. And then if it's for a single individual, they know they want the car to go to a specific person. I liked your idea about naming a beneficiary.
Okay, I think that's a good suggestion. I concur with you about the joint ownership. Alexa, I'm going to come back now. We're going to talk about the next, I think, really the next big bunch of assets that typically show up in a will project, and that is bank accounts and brokerage accounts. So, what information do you like to collect about these assets?
I like to collect the financial institution's name, where they're holding the account, the type of account, the account number if available, an approximate idea of the account balance, as well as how the account is titled.
So tell me why, the name of the bank or the account balance or the account number is important to know.
This information helps family members or fiduciaries identify and locate assets, especially if probate becomes necessary. When a client comes into my office for administration, often their first question is, I don't know what was there. How do I find it?
This is so true. This is so true. Now, why is the title owner of the account important to know as well?
The title will tell us whether the account's going to pass through probate or whether changes might be appropriate to simplify the administration of that asset at their death.
Okay. When you say ownership, I mean it could be held jointly, for instance, and so it would pass by joint ownership. John, I'm going to come back to you now. Is it a good idea, though, to add a child or a third party as a co-owner of an account just to avoid probate?
I'm not going to say never, but I'm going to say that is almost never a good idea. There are a lot of hidden costs to that. One being the child who's added to the account may or may not understand or care that it's mom and dad's wish that it be divvied up among other beneficiaries upon their death. There are potential gift tax consequences, and that account can also potentially be liable to the creditors of the child, which mom and dad might not intend to do.
So, why do you think people name that child on the account? Give me some of the things that you hear in your experience, John.
One thing I hear all the time, like every week, is that somebody at a bank told them to do it, and that's a good idea to avoid probate. That, to me, that is a true statement. It will avoid probate if the child survives the parents. but that is a rather myopic view towards how to accomplish their goals.
Sure. Yeah, I know one early in my career, I did come across a lady who came in with a brokerage account of almost $500,000. She had no children, but she had a niece. And so just so she had someone to take care of this, she put her niece on the account as a co-owner. And I said, well, that's going to be a problem in case your niece has some creditor issues, if she has some creditor issues. So yes, you've got to be very careful about that. All right, Alexa, let's come back and talk about some things that are kind of a potpourri of things, which is anticipated inheritances, maybe gifts that you're expecting, or maybe you have a lawsuit judgment you're expecting to collect on. Tell me a little bit about why this information might be important in a will estate plan.
So these types of assets can create important tax and planning considerations, which may affect decisions about whether that person should accept or disclaim an inheritance, continue a lawsuit, or structure the transfer of their assets. So it's helpful to identify these types of assets early on and discuss the available options with your attorney.
Now, John, I'm just going to come back to you for a second, though. Do we also have to be concerned about the tax basis of assets that might be gifted prior to someone passing away?
Absolutely. It's another potential landmine. Generally speaking, if an account is held between parent and child, jointly 50-50, there is going to be a 1/2 stepped up basis rather than a fully stepped up basis upon the parent's death. There are some exceptions to that rule, but it is not the case that there's automatically going to be a basis adjustment that the parent might be going for.
Okay. All right, Alexa, I'm going to come back to you. Let's talk about some closing comments. This is the first part of a two-part show it's talking about the what, which is the assets that we're dealing with. So tell me a little bit about some final thoughts you have for our viewers as far as pitfalls to avoid, suggestions that they might want to consider as they begin to assemble information for their consultation with their estate planning attorney.
So the best estate plan starts with complete and accurate information. You'll get the most value from your meeting with your estate planning attorney if you come prepared with a complete inventory of your assets and an understanding of how those assets are titled.
Okay. Now, and have you found, because you do a lot of probate administration, that people either forget to tell somebody about something, or maybe they've named the beneficiary, but that beneficiary has passed away, so then an asset now is forced through probate? Have you found that to occur?
Yeah, that's one of the most common reasons why folks who had worked with an attorney or taken steps to avoid probate still end up with assets in probate, because they weren't carefully reviewing beneficiary designations, or they forgot they had an asset. Sometimes we see folks forget they had treasury bonds and they found them as they were cleaning out the house, things like that.
John, how about yourself? How about some thoughts you have, some words of advice, some pitfalls you think people kind of fall prey to in the course of a will estate plan?
Since you mentioned the idea a few minutes ago of parents maybe adding a child as a joint account holder, what I see as a better alternative to that, if the concern is making sure that there's somebody available to pay the bills, is add the child or somebody else as having check signing authority without naming them as an owner. That way, a lot of these pitfalls I was talking about can be avoided.
I think that's an excellent observation, John. We see that regularly. The banks don't have a form power of attorney to let you do that, but you can get a simple one-pager that allows them to be in charge of account A, and so at least they can write checks. Now, keep in mind that power of attorney, of course, is only good as long as the person's alive, and it disappears when they pass away. So you may end up in probate, but I think that's an excellent suggestion, and we recommend that on many, many, many occasions. As I look through the discussion so far this evening, we have a little bit more time. I wanted to just discuss any other pitfalls or problems that you've seen in the course of your practices. Alexa, how about yourself, that people ought to keep in mind as they start to disclose information and make plans to develop an estate plan with their attorney?
I think sometimes folks can be sheepish about sharing their financial information with their attorney. So I think it's very important for folks to understand that we can't advise you on the best course of action for your estate plan if we're not given complete information.
Do you make people affirm the information they've given you is everything, so that you have some record about that in the course of doing a project like this?
No, not necessarily something formal I have them sign, but in every consultation I do with a potential estate planning client, I have a checklist of assets that I'm running through and making sure at least I've asked about that asset. So to give them an opportunity to disclose, even if it's something maybe they've forgotten about or weren't considering as an asset.
John, and coming back to you before I go to our closing here, in the course of reviewing people's existing estate plans, do you really try to dig out from them any missing assets that they might have forgotten the first time around?
Not in the ordinary course. In some cases, a client will drop a hint that there are other assets out there, and in that case, I try to dig in a little bit more.
Sure.
In case they're really hiding something.
Sure. Well, guys, I can't tell you how great this has been today. This is the first part of a two-part program. On behalf of, the Probate Nation television audience in Virginia and around the country, I really want to express my grateful appreciation to John Morgan from the law firm of Rees Broome and Alexis Abraham from the Bromley law firm in Fairfax for sharing all of this great information. Thank you for this really awesome and valuable public service, guys.
It's been a pleasure.
If you have a plan to meet with an attorney to discuss creating a will, this show is an excellent preview of some of the asset information you will need to disclose. And next week we will complete that review of that asset information. Hopefully you will be motivated by these shows to carefully collect and disclose all the information needed about the assets in your estate. If you do so, your will plan will accurately implement your wishes, your family will thank you, and you will save some attorney fees along the way. This brings us to the conclusion of our show. I hope you found it helpful. Replays can be viewed on the Probate Nation YouTube channel, and if you want to receive monthly estate planning and probate tips, please sign up for the free Probate Nation newsletter at probatenationnews.com. Many thanks for tuning in. Until next time, I am Richard Ruddy, and this is the Probate Nation.